On September 8, 2013, the Georgetown waterfront felt like any other humid Sunday night in the district. Erik Supp and his friends relied on a modern promise, a safe, private ride home with one tap. But that tap summoned a nightmare that would challenge the very definition of 21st century employment. The driver, Johannes Deresse, arrived acting erratic. Sensing immediate danger, the group abandoned the vehicle within seconds. Deresse didn't drive away. He pursued them on foot, escalating a verbal confrontation into a physical hunt. The resulting lawsuit, Supp versus Uber Technologies, landed in the DC District Court. As Supp pleaded for peace, Deresse drew a knife, plunging it into Supp's chest and arm 6 times. Bleeding out on the pavement, Supp's life hung by a thread as emergency responders rushed him to surgery. Doctors performed a diagnostic laparoscopy and extensive muscle reconstruction to repair the brutal damage. Supp sued Uber on 2 primary theories: negligent hiring and vicarious liability under an agency theory. The plaintiff argued Uber assumed a duty of care by marketing rigorous background checks to its users. Uber countered that they are a technology platform, not a carrier, and Deresse was merely an independent contractor. Judge James Boasberg opened his ruling with a nod to Forrest Gump. Life is like a box of chocolates. The court dismissed the negligent hiring claim. Why? Because Supp couldn't identify a specific red flag in Deresse's past. However, the court refused to dismiss the agency claim, ruling it was premature to decide if drivers are employees. The court found that Uber's control over the ride process created a plausible case for an employer-employee relationship. While the case stayed at the district level for discovery, the ruling dealt a massive blow to Uber's independent contractor defense. The takeaway for practitioners: marketing claims can create a duty of care that overrides a user agreement's fine print. In negligent hiring cases, finding the red flag is everything. Without it, your claim is dead on arrival. If you're suing a tech giant, don't just argue the contract, argue the control.